We have filed 4 sets of documents. Number 1, a preliminary objection dated 25th of November 2022, a replying affidavit sworn by Charles Muredhi Launi on the 25th day of November 2022. We have filed written submissions dated the 26th day of November 2022. And we have also filed a list and bundle of authorities dated 26th of November 2022. My lady, we will in summary be making 4 points. Point number 1 is that this court has no jurisdiction at this stage of the dispute to issue the conservatory order sought or any other relief of that character. The operative issue in our objection, my lady, is at this point in time, and I'll clarify that later. Point number 2 will be attempting to show you that in any event, she has not made out a case for the issuance of conservatory orders or an order of that character. My lady, in the event you disagree with us, because the court is perfectly entitled to disagree with us on those 2 points, we'll be making the point that even if it were to be assumed for argument's sake that they have a good case before you, our submission is they don't. The solution does not lie in the issuance of a conservatory order or any order of like character, and that this court, if it finds any defects in the process, it can issue directions on what safeguards ought to be observed in the process without necessarily stopping it. In the event the court disagrees with us on the first 3 points, my lady, we'll be hoping to persuade you, notwithstanding the merits or demerits of their case, based on our lived history and the nature of society we have, the court would be establishing a very dangerous precedent which would have the effect of emasculating the mechanisms in our Constitution for public accountability and political accountability set out in Article 181 of our Constitution as read with Section 33, and the standing order in question, which is standing order number 65. I begin with the first point, my lady. Luckily, the matter before you is not new. What is before you is exactly what happens and what has happened since we got this 2010 Constitution. Whenever a governor has been threatened with impeachment, they rush to court. So luckily, there is no shortage of judicial opinion on whether the relief being sought from you can issue at this stage. Our submission in simple is that there is binding precedent from the Supreme Court of the Republic of Kenya in the case of Justice Kariuki Mate and another, versus Martin, Nyaga, Wambora, and others. That is Supreme Court petition number 32 of the year 2014. Before I take you through the highlights of this decision, my lady, I wish to point one thing. The petitioner's entire case for a conservatory order is based on the decision of the Court of Appeal involving the same parties as the case I am now highlighting before you. But when you read the authority at page 57, that is the decision of the Supreme Court, you will note the decision they are relying upon was set aside by the Supreme Court. The legal consequence is that that decision is not authority for any legal proposition to the extent that it was entirely set aside by the Supreme Court in the case I just cited for you. When you open the decision from the Supreme Court, which is at page 57, my lady, you note that the crux of it is whether extent to which courts can interfere with parliamentary processes which are in actual progress. What happened in this matter, my lady, is that the High Court issued the order you're being asked to issue. The Assembly nonetheless ignored it and impeached the governor for embattled. The High Court vacated the impeachment on the ground that it was in violation of a conservatory order. The matter went to the Court of Appeal, where my friend would have you leave the proceedings. And the Court of Appeal agreed with the High Court. However, my lady, when the matter went to the Supreme Court, a number of things are noteworthy. One, the Supreme Court ruled that orders of the type being sought from you should not issue, that the processes should be allowed to run to their logical conclusion, and if there is a dispute, then it can be ventilated. But the judiciary cannot hamstring. That is the language the Supreme Court used. It cannot hamstring. The Supreme Court went on, my lady, to say something I've never seen, which is why this is important. That because the judiciary had hamstrung the Assembly, contrary to the doctrine of separation of powers, instead of waiting for the process to end, the Supreme Court actually ruled that on the facts of the case, that was a good ground not to give effect or not to obey the conservatory order that had been issued. Number three, my lady, which also I don't usually see in my few years of practice, now 15 and counting, when you read that decision, you'll find the Supreme Court did not just stop at reversing or setting aside the decision of the Court of Appeal, which is the one that was before it. The judgment says the conservatory order is annulled. What usually happens with appellate courts, my lady, is they reverse or set aside. It must count for something that the Supreme Court not only strongly reprimanded the High Court for issuing conservatory orders at this stage of the dispute, but actually annulled. That's another polite way of saying the order was null and void as initially issued. And that is the context in which the Supreme Court says such an order could not be given effect to. So to the extent, my lady, that the Supreme Court has ruled the court has no jurisdiction at this stage of the process, there would have to be something very exceptional, very dramatic, that would give this court the courage, given the provisions of our Article 163(7), to nonetheless issue. And time permitting, I'll actually show you a case where the High Court has the courage to issue them in very unique circumstances which do not now hold before you. That position, my lady, of the Supreme Court is reflected in yet another decision from this court by the late Justice Louis Onguto. The decision by Justice Onguto is the case of Mwangi Wairia and two others versus Speaker Murang'a County Assembly and two others. When you read that decision, what is the extent to which it has been violated? It is not enough to sing Article 50, Article 47, or whatever. I mean, my lady, anyone can do that. That's the easiest thing to do. That decision of Anarita Kariminjeru, my lady, is set out in page 13 of our bundle of authorities, which is also bound together with our submissions. And the particular excerpt, my lady, is on the third paragraph at page 18 of our bundle. My lady, in fairness, it's important to point out that initially, Mutuma and I weren't born when this decision was issued. The remarks there, which have now become law, were initially issued as obiter. I don't know whether Ndeg Wanjiru was born. He is whispering something to me. 1979, my lady. My lady, that rule that a petition alleging infringement of fundamental rights and freedoms must demonstrate with reasonable degree of clarity the specific provision that is breached and the manner in which it has been breached has been confirmed by the Court of Appeal to be the law, now not just obiter, as initially issued, in the case of Mumo Matemu versus Trusted Society of Human Rights and 5 others. That decision is at page 22 of our bundle. So it's no longer just obiter. And again, on this case of Mumo Matemu, my lady, again, the courts issued various orders, reversed certain appointments. The Court of Appeal eventually ruled, actually, the petition was a non-starter right from the outset. It never met the basic threshold of Anarita Kariminjeru versus Republic. Let me now take you through why we say that they have not made their case anyway, even if we are wrong on all these technical things. They tell you the motion has been signed by a stranger. We have annexed at page 19 of our replying affidavit a document that shows the person who received the motion is the deputy clerk. 19 of our replying affidavit. He is the deputy clerk. Number 2, my lady, we have in our list of authorities showed you that Section 21 of the County Assembly Services Act, which is at page 172 of our Bible, empowers the Deputy Clerk of the Assembly to exercise all the functions of the clerk during moments of vacancy or inability on the part of the clerk. So nothing turns. If that is the prima facie case, then it is also prima facie that they have not understood the actual position. They tell you the matter is sub judice because one of the grounds is that there is a case before the ELRC and it's one of the grounds of proposed impeachment. There are a number of things they haven't done, my lady. One of them is they haven't told you that that ground is only one of 15 grounds. So even if you are to believe that that is correct, you'd still remain with 14 main grounds of impeachment. But they also haven't told you, although the main grounds are 15 in number, the specific grounds of impeachment are 68 in number. I don't know whether it's coincidence, my lady, that there are 68 grounds and there are also 68 members who signed it, but we will deal with the issue of the members. But there are actually 68 specific acts and omissions that inform the proposed impeachment. They also didn't tell you that under Standing Order 90, which they were happy to read to you, the parts that suit their case, but they didn't read for you the part of Standing Order 90 that doesn't support their case. And when you read the whole of Standing Order 90, which they have annexed, my lady, you will note it is not the mere pendency of a case in court that makes the matter sub judice within the meaning of Standing Order 90. One, you have to show in the case of a civil dispute that it has been fixed for trial. They have not mentioned that. The matter is still in the interlocutory stages. You have to show, they mentioned this, but they didn't show you how, that the impeachment motion would prejudice the fair determination of that matter. You have been told the Assembly is biased because 68. My lady, the law only requires a minimum number of MCAs, that is 1/3. It does not forbid supermajorities from signing onto that motion. But if we are wrong, my lady, given the sentiment from the Supreme Court, and given the Supreme Court tells us the Assembly and the Senate as the appropriate forums, the fact that it has been signed by 68 is equally a ground for restraint on the part of the court. That's the other side of the coin, even if we take it that they are right. But my lady, again on that issue, the Senate is the constitutional safeguard against any bias, against any malice, against any mischief on the part of the Assembly. And I invite you, my lady, to take judicial notice that there are very many instances when county assemblies have impeached a governor and the Senate has refused to uphold the impeachment. So when the Supreme Court and Justice Onguto tell you that the Senate is the actual locus of the relevant events and it is the actual safeguard, it's not for nothing. They are telling you fair trial, Article 50. They have not told you how it will be breached. But also what they haven't told you, from their own authority, the one they are relying on, although it was reversed by the Supreme Court, we are told impeachment is a tool of policy and political accountability. It is not about civil liability. It's not about criminal culpability. Therefore, the invocation of Article 50 is misconceived. And this view, my lady, is that the matter before you is not an Article 50, it's not about civil or criminal culpability, can be confirmed from their own decision, which we have actually annexed in our Bado at page 123. It is the holding number 4 from the Court of Appeal. They have told you, my lady, that the reason this good lady is having this problem is because she's a woman. They have not attached a single document to show you these utterances. They say they were made by the move of the motion. They were made by certain male politicians. Not one of them is attached or even referenced so that we know it exists. Maybe they were just not able to lay their hands on it. They have told you legitimate expectation that she would serve for 5 years. Now, the constitutional provision that provides for a term of 5 years is not more important than the constitutional provision that says if you engage in certain types of conduct, you could be impeached, and that term will be cut short. So again, the claim for legitimate expectation is neither here nor there. They have told you the reason MCAs are this bitter, and the reason 68 out of 69 have signed this motion, the real issue is the Ward Development Fund. Why that cannot be a prima facie basis, my lady, is one, the impeachment motion does not even mention, even in one of the 68 grounds, anything to do with the Ward Development Fund. The document speaks for itself. The other thing they haven't told you is that even if we were to assume, because my lady always do my litigation on the assumption that the adversary is right, even if we were to assume, for argument's sake, that that's one of parts of the driving factors, they didn't tell you MCAs who have no stake on the Ward Development Fund, specifically nominated MCAs, have equally signed that motion. Yet they have nothing to gain or lose as far as the Ward Development Fund is concerned. They have told you the clerk has short-circuited the process. He's jumping the gun. They have told, yes, there are a number of things they have told you on that allegation, and prima facie they are misconceived for the following reasons. One, they tell you the motion has been put in the order paper. My lady, we challenge them to show you. Because what they have annexed is not an order paper. It is a notice paper. And the standing order they rely upon clearly shows there is 2 types of documents, an order paper and a notice paper. I don't know where they got that. The motion has not been moved. So the clerk is just jumping the gun. But what they don't tell you is that this notice paper, not order paper, my lady, and just for the benefit of the court, the notice paper is the document that shows matters that are tentatively planned for business before the assembly. So those matters may or may not find themselves in the order paper when the relevant date arrives. That's the difference. The order paper specifies the events of the day in question. The notice paper is more like a timetable for an entire week. And this can be confirmed from standing order number 39, which they have attached, It can be confirmed from Standing Order number 45, among many others. The decision of Justice Onguto in the Mwangi area case, and even the decision I showed where the order was issued because of COVID restrictions. What they didn't tell you is that all those cases confirm that the process and sequence of events is preordained by statute and the standing orders. The moment the Speaker approves that motion, notice must be given of 7 days, and it must be debated and voted upon by the 10th day. The reason, my lady, as you'll find in the replying affidavit, it became therefore necessary, guided by that Supreme Court decision and the other decisions, was that that is the only way the public participation could have been held. Because if you wait for the 7 days and you must dispose of the business within 3 days, it would mean there would be no room for public participation. And our answer, therefore, is this complaint about the newspaper is misconceived. It is based on a misreading of the timetable cast on statute, and the Supreme Court has said a lot about those timelines. So the assembly cannot be faulted, the clerk cannot be faulted. You have been told the reason you should issue the order is because the assembly is not infallible. We agree it is not, but none of us is, not even my lady. And therefore, that really, without more, cannot be a ground for unstringing the process contrary to the decision of the Supreme Court. They tell you there is no nexus between the governor and the allegations in the motion. The motion does not lay the nexus. Two answers. First of all, the motion speaks for itself. We'll leave it to my lady to see whether it establishes that nexus. But more importantly, the Supreme Court has held, Justice Onguto has held, the other case of Ayano Iguru has held, that the forum for establishing that nexus is not in a court of law. It is not even before the county assembly. It is at the Senate. So it is them who are actually jumping the process, even as they accuse the clerk. And this decision can be confirmed, the case of Mwangi area, at paragraph 92, my lady. That's why Justice Onguto held that issue of nexus, the courts are not the appropriate forum. They tell you there is a glaring loophole and that there is a serious constitutional question that must be determined because Section 27(4) of the County Government Act, as read with subsection 5, puts a moratorium of 24 months before you can recall an MCA. And they tell you because there is no similar provision putting a moratorium of 24 months before you can impeach a governor, therefore the court should make law and create such a moratorium. That is the main question they tell you, is a weighty question of constitutional law. My lady, what they're asking you to do is to issue an advisory opinion. That jurisdiction lies with the Supreme Court, not with this court. And in any event, if you check our preliminary objection, we address the question of justiciability. And number 3, my lady, they're asking you to make law. That because Parliament has refused to make that law, you make it. Clearly, that's not within the province of the mandate of this court. It cannot be a prima facie reason. The court is ill-equipped to examine the policy rationale why no such law exists. They tell you freedom of religion. They have not showed you how the assembly has stopped her. She's a bishop. So she hasn't told whether the assembly has stopped her from preaching or presiding over Sunday, whatever. We'll be happy to see how that, but there is no evidence, not even an allusion to it. They tell you freedom of expression. They have not told you how an impeachment motion stops the governor from expressing herself. No evidence produced. Not even weak evidence, my lady. They tell you Article 37, correction of deletion of untrue and misleading information. They have not told you which are these untrue and misleading statements that have been made against the governor that would supposedly require correction and deletion. They have told you Article 47, the public participation has been promised. As a matter of fact, it was taking place today. She has been given a right to respond in writing if she so wishes to the motion. When you go to page 50 of their own annexure, the second paragraph tells her that the motion was laid on the table. The very same motion they were telling you has not been laid and has not been moved. By their own annexure, it says it was laid on the table, pursuant to Standing Order number 65-2. But more importantly, my lady, she is again invited to appear before the Assembly in a sitting of that year for purposes of making oral representations. If you check the other letter, she was given the opportunity for written representations. She has now been offered an opportunity, in addition, oral representation, and she has in addition been allowed to appear either in person or through an advocate. And she has been told even when she appears, she will also have the opportunity to respond at page 51 to the issues raised in the debate. Now, not the issues in the motion. The issues raised in the debate. She has also been promised, which is this Article 47. We would want to hear, after all those undertakings, which is this Article 47, and Article 49, and Article 50 and 51. She has told you a complaint about illegally obtained evidence. But she has not told you, not in her submissions, not in her pleadings, which is this evidence that was obtained illegally. And that's why, my lady, we say, this case does not meet the threshold in Anarita Karimi Jero versus Republic. She's telling you EACC is investigating some of the allegations. Again, she forgets there are 68 specific allegations. She has not told you how that could possibly be a bar to impeachment. And she has told you, lastly, she will suffer prejudice. The answer of which we got from Justice Louis Onguto, that it is premature at this stage we are talking about to talk about prejudice or irreparable harm or the matter being rendered nugatory, because, my lady, when you read Justice Onguto's decision, because you are given an oral scenario that she may be impeached, the governor takes over, Justice Onguto has said it in black and white, that even if all these processes were to be allowed to go to their full conclusion, and the governor were impeached and removed from office, and the deputy, so on and whatnot, the court would still have a jurisdiction after the event to interrogate the process, and if they found that she was not fairly impeached, to reverse it and return her to the position. So the question of prejudice doesn't arise. So, my lady, I have so far addressed you on my points. I want to summarize by telling you as follows, and I don't know how much time I have left.
You have 18 minutes.
18 minutes. So, my lady, I will just say two things, then I'll allow my colleague to use the remainder of our time, Mr. Boniface. I sincerely hope I have shown you that this dispute before you is just one of those where people allege article this, article that, article that. without really laying on a prima facie basis, because at this stage we are not interrogating the merits, a basis for invoking that article, contrary to Anarita Karim Njeru. I've shown you the policy and position of the Supreme Court. But if I am wrong, my lady, and I have been wrong very many times in my career, so I won't be surprised. If I am wrong in all these things I've told you, and they are right in everything they have told you, it does not necessarily mean that you must issue a conservatory order. The court may agree with them that they have laid that prima facie case, the court has jurisdiction at this stage and whatnot, but your jurisdiction under Article 23 is to issue appropriate relief. And what is appropriate relief is not just a relief that pleases the applicant. It must be a relief that balances all due considerations. And we suggest that relief, my lady, if you find any fault with the process, you can give us guidance on how the business that is pending should be, the remaining stages should be concluded. That will still be a relief. It will be within the ambit of appropriate relief. My last point, so that Mawira will have some time, my lady, is what I told you, the scheme of incentives. My understanding of why the Supreme Court lambasted the High Court in the manner it did is that issuance of reliefs such as those sought before you without good ground would create the incentive to every governor who is faced with impeachment to rush to courts, save in the knowledge that the courts will too readily issue these orders and therefore frustrate processes that are time-bound under the Constitution, processes that are time-bound under the Section 33 of the County Government Act, and in fact, emasculate Article 181 of our Constitution. My lady, there was a point, part of the reason we had issues in the constitutional reform process about vetting of judges and whatnot, courts at one time made it impossible, by way of example, this is a matter the court can take judicial notice. At one time, our court made it impossible to prosecute anyone for corruption because they would quickly rush to court and say, my fundamental right to this, my fundamental right to this, and the prosecution would be killed. We know where that took our country. And the court therefore must ask itself, if it gives this order, even in good faith, what scheme of incentives does it create for political players? Because for them, the message will be, all you need if you're facing this type of accountability mechanism is dash to court, get an order, frustrate everything, and you're safe, which is another way of saying the courts will have killed Article 181. I'll give the floor now to my colleague.